All right, welcome back to Senate Education. It's Wednesday, February 23rd, 3:05 p.m. We have Treasurer Beth Pierce with us, and we are looking at continuing our conversation about our miscellaneous education bill. And one of the things we are considering putting in is H572, the language having to do with teachers who are retired and getting them back into the classroom. And the thing that we don't want to do is do something and then it would have these terrible unintended consequences. Our hope was, and one of the things we've heard, Treasurer Pierce, is just thinking of one example in my county, retired teacher experience. COVID has caused, as you know, a shortage in particular of substitute teachers out there. And then teachers sometimes, are getting sick also. They need to be out for a long extended period of time. We want teachers, retired teachers, to be able to return to the classroom. And not only during this time, ideally going forward, because retired teachers they have the experience. And if they're willing to jump in as long-term subs, short-term subs, year-long subs, whatever they're willing to do, that's good news for kids. It's good news for Vermonters when you have that kind of experience wanting to return to the classroom. But we were told that you have some concerns with H572, which we were going to fold into miscellaneous ed. And so that's why we have you here today to hear your thoughts. So with that, the floor is yours.
Okay, well, thank you very much. I did send over an email today with a memo on this. If you have that, Mr. Chair, it is hot off the press today.
I did receive it, but we're going to ask you, to take us through it if you don't mind, since we haven't had time to
Absolutely.
Okay.
So first, I want to acknowledge that the staff shortages in the education system are massive concern, and we put teachers out there. I have such respect for teachers. They're out in the front lines. They're dealing with a lot of anxiety in their own families. They're dealing with the anxiety of whatever number of children in their classes and their families, and they're trying to get the job done. So I think the world of teachers in any environment, and particularly now what they're going through. And I acknowledge that we're at a critical stage with this. I take a look at things from the financial side as well. That's part of the job, and part that I take seriously. And I look at it from both lenses. And at the moment, as we're looking at this, I think there are other ways to get at this. Right now, retirees have the option of going back after they retire into service at a part-time basis. Essentially, it's at 60% of the salary that the average salary for teachers at that point in time. And we do see people going back out of retirement for that part-time option, or maybe as a substitute teacher using that. And again, you can make up to 60% of the average salary, which I believe is someplace around $39,000. So that is an option that teachers have. In our thought process, we saw that there is an expense to the pension system in doing a more expanded callback and retire and let current teachers come back to work. And I'll explain that in a minute. So I do see a cost associated with that. But I'd also offer up an alternative, which is a cash payment right up front to an existing teacher and essentially longevity incentive to stay. Years back, the state did what's called a retirement incentive, where they gave cash. It was over a 2-year period, so $15,000 over 2 years, and when they were trying to balance the budget, frankly, and incentivize people to leave. And about 300 people took that opportunity back then. This would be the opposite, some type of cash incentive to stay. And I think that that's something that you should take a look at in combination with the existing policy with the 60% of the average teacher pay might provide some relief. When we took a look at the current legislation, we had some concerns that given our historical underfunding and the fact that we've worked really, really hard over these last few years, it's been a very tough process for all of us, the teachers, the state employees, the teachers themselves, the retirement boards, my office, and you folks that have had to make some hard decisions and going to have to make some hard decisions this year in terms of the task force recommendations. And we've done a lot to try to remedy at least part of that underfunding. So it would be unfortunate if we went down that path. And we also have relatively strong revenues at the moment. So let's take a look at maybe that type of incentive being part of the process. And folks say, well, how does this impact the pension? So when an actuary is looking at what you're going to need in terms of appropriations for pension and what those gains and losses might be against your assumptions. So every year an actuary says, based on the assumptions we've made, and we true up those assumptions, we were doing it every 5 years, we're now going to be doing it every 3 years. What you do is you say, what's my assumption about turnover in staff? What's my assumption about how many people are going to retire? What's my assumption about the interest rate that we're going to get on our investment? What's my assumption on mortality in service and in retirement? And they take all that, they aggregate that up, they take a look at your those assumptions in relationship to your current appropriation and provide us a number, which is called the ADEC, the actuarially determined employer contribution, the amount of money that you need to put in the system to stay on a path toward full funding. One of those assumptions, as I said, is turnover, and one of them is retirements. And frankly, partly because of the current crisis, but more also over the last several years, starting around 2010, we've seen that those assumptions, no matter how much we retool those over the time, they don't keep up with events. And I think that some of the, frankly, some of the school reorganization, some of the discussion we've had about teacher-student ratios, some of the other pieces to workload and local budgets have had the impact of putting pressure on those. And if you look, the gains and losses since 2011, turnover, staffing, and retirements accounts for almost 50% of the losses in the system over the assumptions since 2011 to 2021. As I said, one of those assumptions is how people what is their pattern of retirement. The concern here is that if you were to look at that pattern, and you as a teacher have the opportunity to retire, let's say you're going to retire in 2 years, and that was your plan, and then this came up, you might retire a year earlier and take advantage of that and come back to work. So this will change teachers' behavior. It changes staff behavior in the state system as well. And in other states where we've seen these things done, behaviors change, have an impact on the gains and losses. And while we are unable to predict the amount, because we do not know how many teachers would take advantage of this, we do see this as a potential risk to the system. I would not say a large one. I want to be upfront, but it is a direction when we've worked so hard to try to lower those liabilities. We took a look at other states. We didn't want to do this in the absence of looking at the patterns in other states or what they've done with this. And in the letter that I sent you, I looked at had some conversations with other states, as well as looked at the bill, primarily the legislative fiscal analyses of several bills in Michigan, Colorado, West Virginia in particular. I also took a look at other states, Louisiana, Maryland, and other states as we did this. But those three in particular had legislative reviews of the proposed legislation. And it's in my letter. It's page 4 or 5. I never write, excuse me, I never write a short letter, unfortunately. But I'm going to read from one of this. This was, I believe, Michigan. And it says, in general, if employees in a pension system have the ability to retire, draw a pension, and simultaneously earn wages during a period of reemployment, at least a portion of employees are likely to retire earlier than they would in the absence of that ability. It is likely that at least some employees would retire earlier than otherwise and would have faced if the conditions for reemployment were as in the current law. I've ad-libbed a little bit there, my apologies. This would increase the unfunded actuarial liability commensurate with the number of employees choosing to retire earlier than expected. And and the payout of benefits during that period as well. It's not possible to determine the magnitude. This was similar comments we saw in Colorado and West Virginia, in North Carolina. So we also talked to our actuary, and why I did not employ the actuary to do a detailed analysis, because that costs dollars. And if you want us to do that, we certainly could ask. But my assumptions around how this might work turned out to be accurate, that they too would see that this would be a potential for risk in terms of our liabilities going up. Again, I don't think it's going to be a massive amount of money, and there are ways to mitigate it. In fact, the bill has two ways. Well, one way is already built in, which is the employees would make contributions, and I'm assuming that those contributions would not go back to them, so that would at least take care of part of the issue. And the second, which is a suggestion that's been made, is defer this a little longer, so that you have to have a 6-month or year separation from employment before you could come back and do this. That helps, but it mitigates it. But again, the likelihood that it reduces all of the potential negative impact of this on the unfunded liability would probably still be there. There are a few other issues that you need to take a look at. One is that, and this is an IRS law, that there has to be a separation between, to make it a bona fide retirement, there has to be a separation, and at least not an agreement that you leave and we'll hire you right back. Those are not looked at very well from the IRS, and could put a system in danger that creates that type of systematic situation. So there would have to be an understanding that there's no link up between the agreement to come back to work. That would not be considered a bona fide retirement, and as a consequence, could literally put the fund in danger. So we would want to put some safeguards around that, whether it's restrictions about the time frame, one that I just mentioned, or some type of paperwork to, as I say, paperwork. I'm from an older generation. More time on your laptop or your computer to address ways to certify that this is in fact not an arrangement that would contradict that bona fide retirement. A couple of other pieces in this is that some teachers have contracts now that include a retirement incentive. Some are implemented at the direction of the school. In other words, you wouldn't implement that contract option unless the school was looking for it. Obviously, in this situation, you would not be looking to do that. But other contracts, as we've seen in the past, is that it's at the option of the teachers, so they could actually ask for an incentive to leave. So that's in some existing contracts now. This was more prevalent. I first looked at this issue in 2017 with the NEA. It was more prevalent back then, but anecdotal information from our retirement office points that some of those situations still exist. So how it interacts with that contract, those contracts, would be a consideration. The other thing that I noted in the bill is that it didn't have a sunset provision. So my concern is whether this is a one-time look to resolve the current situation, or whether this is a concern, a routine benefit or provision going forward. As we're looking at that, particularly if it's ongoing, but even with the short term, we also have to look at the healthcare issues, because a teacher right now has the option to for retirement pension. They also have a healthcare benefit, and how that would interact. It would probably lower budgets for the school systems, because the person would likely stay on their retirement healthcare benefit, but it would increase as more teachers are retiring than anticipated. Would probably increase our healthcare budget at the same time. I think that bottom line is the teachers do an extraordinary job under very difficult circumstances. I want to see some type of incentive for them. I think that that's important in terms of retention. And I would advocate that doing it, some type of longevity bonus might be the best approach to this. It would not have the unintended consequences in terms of early retirements. And in fact, when we did an analysis back in 2019 as part of the beginning of some of our pension mitigation studies. We saw that retirement longevity incentives had the desirable effect of keeping folks in positions longer, which lower the actuarial liability rather than increasing it. So I think that if I were looking at it, I would want to do something to help keep teachers. I want to look at the way you could do it in the most cost-effective way, and that would be my recommendation.
No, I appreciate that very much. So you've outlined a lot of problems, a lot of concerns with the bill, which I respect, and it all seem to make really good sense. So help us with a solution in terms of this year, if you wouldn't mind, if you can. And I'm just thinking, Treasurer Pierce, we're not only dealing with COVID, but also just the teacher shortage that's is before us and going to get worse. Can you give some thought, even if it's even if we were give some language around people coming back to us with some more specific, I'm not sure. I don't always appreciate studies, but there might be something there. So I'm just wondering if you could help us a little bit.
Sure. Yeah. Well, I think the first step would be encouraging folks to stay, because what we've seen, and it's driven up the cost of the system, is people leaving earlier than expected, is the biggest driver in the turnover in the teacher system, the workforce. I've said this a few times, that we have to look under the hood as to why teachers are leaving. And I think that's important. As the education committee, that's something that you obviously are interested in, and you care about teachers, as do I. And I want to understand what the pressures are that are even outside of COVID, that were pushing decisions to retire earlier rather than later. And I think a lot, as I look, it's not coincidental that around 2010 is when we started to see a lot of the discussion about the student-teacher ratios, pressures on school budgets, and I think that had a lot to do with it.
But even if I may, and I'm sorry to interrupt, but we have all these teachers that are retired right now. I mean, so we're not bringing them right back into the workforce full-time. We're, and some of the things that we've heard are for some teachers, it's also time. They've given their 20, 30 years. They're looking, it's now time that they're really interested in retiring. So with all those retired teachers out there, and having spoken to just the Retired Teacher Association that's part of the town of Bennington, there are a lot of people, a lot of experience there. Is there anything we can do to get them back into the classroom where it wouldn't negatively impact the pensions, et cetera? Or are you saying that's impossible? We really need to pivot and not focus on those folks that are retired. They're going to be able to come back in for a limited time, but really focus on the people that are in the classroom now.
Well, I think that there is a current method for teachers to come back using that 60% of salary. And I think that if you've retired, you may not want to work full time. You might want to work as a substitute teacher here and there, and the like, and it gives you that opportunity. And it's built into our current analyses. So I think that there is an option for teachers. I would have to go back and I can't ask our staff how many people actually avail themselves of that opportunity. And we can take a look at that.
Okay.
But I think overall, the other is, again, because it's really driving up the cost of the teacher system, because teachers are leaving. Why are they leaving? And what can we do to help them? So I'm just going to say it up front that I think the teachers are under incredible pressure, incredible misconception of their value to the community. We criticize and we don't recognize that they do so much. I could never be a teacher. And I have so much respect for the people that are. And I think that we should make a real effort to find out how we can help them moving forward to have an environment that is conducive for them staying.
Senator Lyons.
Thank you. And thank you, Treasurer Pierce. This is, it's always a great conversation to hear your perspective. And I understand what you're saying. We get it. The people that I'm hearing from are the retired folks, and as Senator Campion was mentioning, who have really wanted to get back into the classroom during this critical time, see the teachers who have had to leave or been so overwhelmed, left as a result. But they'd want to get back in, and then they say, well, we can't because of our pension and all the financial issues are getting in the way. We didn't have that problem in healthcare when we brought back retired physicians. They don't have a pension, that gets in the way. But the question I have, and I'm trying to think, what's the solution? A short-term solution while we regroup. We haven't even started to regroup. Let's face it, we've got months to go before we're in the regroup situation, but we need to prepare for that. And so while we're doing that, why not have a pilot program that would allow for some forgiveness on pension issues, or how resolved as it is in the bill, a pilot program for 1 year or 2 years or whatever decision we would make, and then look at the ramifications of that, the results of that. We could put in criteria that it's only for teachers who have been retired for more than 2 years. So the conditions that you're talking about that might mitigate or eliminate some of the concerns that are out there, but just because we need teachers right now, and we've got a good group out there ready and willing to participate. So I'm just thinking, do something short term, collect the data, and that would include the financial data that your office is interested in. It could help us with that. And then, some of these folks may not want to stay in that position for more than a year, but at least give it that try.
So a couple of things in there that you mentioned are very helpful. First, I did not see a sunset provision in the bill, which concerns me because
You could easily add that.
Yeah. And the other piece is the discipline after that. One of the states I've talked to, they've had a sunset, and every couple of years, a sunset becomes sunrise again. And so it's important to have some discipline around that. Once you put something in, it's really hard to take it away. So I think that would be something that if you're talking short term and is limited, your suggestion, Senator, about 2 years, it might even be longer than that, because what you don't want to be in is a position that says that I'm going to retire in 2 years. I'll do it now, and then be able to get this option on my plate. So you might want to say with 3 years or whatever, but prior to whatever date, so that, it's not a new teacher making that decision. That might be a possibility. I'm not saying that I think that that's a great idea. What I am saying is that I think that there are things that you could do to mitigate the input. But I really strongly feel that retaining, because this has been the biggest issue in this fund in terms of its increase in costs over the years, is that the rate at which teachers are leaving. And I think that this is an opportunity to work on that as much as it's an opportunity. And an incentive might work, and you can do a model on that, and see what the result is if it has a positive impact on the unfunded liability by incentivizing people to stay. Now, those dollars cannot come out of the retirement fund. You can't incentivize and use those dollars to do it. You'd have to use operating cash, just as we did back in 2010 with the state when we did the retirement incentive, which was, give you cash to leave at that point in time. And that was in many ways a mistake. And this gets back to the discipline. Once you do something, at the time they said, well, we're going to keep of the 300 roughly people that retired, we're going to keep 100 positions open, not fill them, so that we can cover the cost of the increase to the cost of the retirement system, which was about $2 million at the time, in the not cumulative $2 million per year in the actuarially determined employer contribution. I think it was and I'm doing this from memory, but we'd have to keep 100 positions open. So in 2010, I looked at the 2010 number of retirees and the number of retirees in 2000 the number of active employees in 2010 and the number of active employees in 2014. And the number is still ingrained in my memory. It was 543 increase and not 100 reductions. So we added to the workforce instead of reducing the workforce. Now, I would argue that that there was a good chance that those people are absolutely needed. I take a look at the front lines, and I take a look at what social workers go through, what corrections officers are going through right now, and I think the state needs to do a more comprehensive workforce analysis. Period. I don't know how we've deployed it, and I'm not a workforce expert.
Yeah, and I don't want to get too far
Sure.
out of this.
But I think my point is, though, that the discipline that was there that said we're going to leave those positions open didn't occur. And my concern on the other side is once you start something, it's hard to pull back. The discipline involved in that is tricky, particularly when you're talking about a lot of school systems. If we couldn't manage it with one employer, the state of Vermont, I'm not sure how we would manage it with multiple employers. I'm not sure actually how many LEAs we have. I know, the number of regional. So I think that my point would be that the discipline around that and putting very big parameters around it. There's less involved in that, but less. And again, my thesis is do what you can with the teachers to keep them and retain them.
Senator Perschlick.
Thank you, Chair, and thank you, Secretary Pierce, for your testimony and this memo. I haven't digested it, but it seems like a great resource for us as we continue. And because at first it seemed like kind of a no-brainer, because it was hard to see how it was an issue on the pension, because pension's paying the teacher whether they're working or not. But I now better understand the issue as it relates to early retirement and what that causes. But I was thinking of the same thing as Senator Lyons about just saying this only impacts the current pool of retirees, but you have that issue going forward. But I wondered if another option is to say it's only for those that met the full retirement. So whatever that full retirement, however that's defined, and we could define it, say only those people could come back, and you could still limit it, but we're just have so. I would worry that if we spend too much time kind of studying it, we don't deal with the current crisis and difficulty. Some schools had a hard time staying open because they didn't have enough staff. So we want to be able to have at least some kind of emergency situation for now. But I hear what you're saying about the discipline. If we mean it to be temporary, we really have to make sure it's temporary. So thank you.
I think the idea that you just had too, that folks that essentially retired in normal retirements as opposed to early retirement is a good piece. That might actually be something I'd have to talk to our legal counsel. That might have been the expectation from the IRS. Anyways, I don't know the answer to that. When I start talking like a lawyer, I'm in real trouble. I should stay in my field of expertise.
So that sounds like there might be an opening there for you to go back if you're willing to talk to folks on your end around Senator Perschlick's idea and let us know if that might be a path forward.
Right. And we still need to deal with the healthcare issue
Sure.
in terms of, frankly, I think the retired teachers have a pretty good plan. So.
Okay. Anything else for Treasurer Pierce at this point? It's very helpful. Appreciate your willingness to continue to dive in a little bit with your legal staff. Okay.
Well, thank you for the time, Senator, and it's nice to see you all again. It's
Good to
been a
see
long
you.
time. It's been a long time. I hope we
Too
can see
long.
each other in person. Thank you. Bye-bye.
Thank you. Committee, we have a little time. I'm going to ask Beth St. James. Ms. St. James, are you there? Would you be willing to take us through the new version of the mascot bill?
Sure, I actually just heard back from Emily too, so it's good timing.
Terrific, great. So committee, that was emailed, and I believe Daphne also has it up on our website. So give everyone an opportunity to find it before we jump in with Jim.
Is that draft 4.1?
It is.
Okay, thank you.
Thank you.
I don't see it on the website. Is email?
Looking
It's
to
there.
Kath-
It's there. Just refresh your page.
283. This is S280. No, this is not 283. I'm sorry. This is 139, draft 1.4.1. Do you have it, Senator Chittenden?
I don't see S139.
This would be under Elizabeth St. James.
Okay,
Today.
sorry, I'm on the wrong day. Cheers.
Okay, no problem. Okay, Ms. St. James, the floor is yours.
Thank you again.
For those watching, just a reminder, this is a new draft of S139 based on the proposal that Secretary French brought to committee earlier this week. So with that, please, thank you.
Thank you again. For the record, Beth St. James, Office of Legislative Counsel. This is draft language based on, as Senator Campion just mentioned, the AOE proposal you heard yesterday. I did just hear back from General Counsel Emily Simmons, and she had no comments other than one request to change a date, which I have not done yet. But I'll flag that when we get there. This bill begins with Section 1 as session law and legislative intent language. I will just say before reading, going through the actual language here, which I hope the committee will give me some direction on, is that traditionally legislative intent or policy and certainly findings is drafted in session law and it's not included in the Green Book. There have been occasions where legislative intent is included in the Green Book in statute. So I've drafted this in the more traditional approach, which is in session law. But since I've labeled it as legislative intent and there are occasions where that appears in statute, I just wanted to flag that as a policy decision.
So let's pause there for a moment. It seems to me that we would want to put it in the Green Books, put it in statute. Well, why don't we start this way? Can you say a little bit about why we would, why we wouldn't, some of the benefits, that kind of thing?
Sure. The Green Book. First of all, as you all know, the Green Books and session law have the same effect. They're all laws. It's just a matter of, in the most basic sense, where one is found. The statutes, the Green Books, are really the law on the books in perpetuity until this committee or someone sitting in those seats changes it going forward. Intent and findings are almost never included in the Green Books in statute. They're put as reference points and included in the act itself, which is memorialized in session law. Legislative intent, findings, policy are sometimes looked to if there are legal disputes. It can be looked at to help a court or a trier of fact determine, in this case, legislative intent, just as it is labeled. The effect of the language is the same no matter where it's included. But session law is the traditional in place to include this, but I will point out for the committee's benefit that the harassment, hazing, and bullying statute, which both AOE and I relied on in drafting this, does include a legislative intent section in its statute. So it's not unheard of. But I just went with the more conservative traditional approach here and happy to change that.
It's up to the committee. The traditional approach is now fine with me, actually. But if, again, for consistency purposes around the hazing, harassment, bullying, Senator Perchlik.
Thank you. I don't care anymore, but there was a time when it mattered what you put in the Green Books because we were printing them all and, we would have them around and you'd have to carry them around and then you'd have to just have all this extra language that you have to deal with. But these days you can just do a word search or, so it's not as kind of superfluous to have that in there. So I don't care as much as I might have in the past.
Senator Lyons.
I guess the only reason that I would care about this, and I don't, I'm not passionate about it, but I would care about what happens when there's a court case. And we know that the issues that we're dealing with here have already led to court cases. I don't, maybe it's enough to have had it in the green books. And that's a question I would ask Miss St. James. If we have it in the, not the green books, the other, I was going to say seasonal.
Session law. It's
Session law. Thank you. Oh my goodness. I think I'd know it all these years. So if we had it in session law, it was still there and it would still be available for a court proceeding. So it doesn't need to fill up the green book. Just talked myself out of what I was going to try and talk myself into.
I'm really glad you raised it, though. I think it's okay. Senator Hooker, you look concerned. Are you okay with the traditional past practice and not putting it into keeping it in session law?
Yeah, I mean, I don't know. I just look at the green books as having gravitas, but I don't know that makes any difference. But as long as the information is available to the courts, I think that we can go with the traditional.
Okay. I think we have consensus. Thank you, Ms. St. James.
So the language that I cobbled together for your consideration reads, it is the intent of the General Assembly to ensure that all Vermont schools provide positive and inclusive learning environments for all students by eliminating the use of discriminatory school branding, which undermines the educational experiences of members of all communities and perpetuates negative stereotypes. All Vermont students should feel safe and welcome while enrolled in a Vermont school.
I think you did a great job with that. Really terrific. Thank you.
Section 2, line 14. So you're adding a statute to the school, and I didn't pull up everything for you because this is on the fly, but let me just, someday I will have all of this memorized. So the school district's chapter is chapter 9 in Title 16. And since this is now really a school district issue, to adopt the policy and deal with complaints on the grounds level, I've inserted this whole concept into chapter 9, the school districts chapter, and created a new section 568, school branding. It actually fits in nice. That puts it under subchapter 4, which is just titled Other Provisions. So I think it fits in nicely there. It begins with a definition section. It defines school branding. It's the same as the definition that appeared in earlier drafts of this bill. Any name, symbol, or image used by a school as a mascot, nickname, logo, letterhead, team name, slogan, motto, or other identifier. School is defined, meaning a public school or an independent school approved under section 166 of this title. And school board is defined here as the board of directors or other governing body of an educational institution when referring to an independent school, because an independent school is not a part of a school district. So throughout this bill, you'll see references to the school district's response or the school board's responsibility. So this is just defining what that means for an independent school. And it's the same definition as the hazing, harassment, and bullying policy that's already in statute. Section 2, page 2, subsection B, model policy. This is the section that requires the Agency of Education in consultation with stakeholder groups, including the Vermont School Boards Association, to develop and update a model non-discriminatory school branding policy. And then the policy shall prohibit school branding that directly or indirectly references. And then lines 7 through 13 are the same as what was in the previous draft of this bill under the SBE proposal. Nothing has changed there. Oh, and I will note, there was some discussion last time about whether Native Americans would be included in this language, and I feel confident that they would be. One, this section, line 10, subdivision A, is almost identical to the protected classes in the Vermont Public Accommodations Act. The only thing missing there is sex, which you could argue is covered under gender identity and marital status. And the other thing I will say is that the US Census includes Native American as a category under their race questions. So I think that it's covered in that those categories. We're on line 14, page 2. The policy shall provide a process for an individual to file a complaint that an element of school branding is in violation of the policy. Complaint shall be determined first by the school board of the district, and if the individual is unsatisfied with the decision of the board, may be appealed to the Secretary of Education. The policy shall also require school boards to review the district's school branding to ensure compliance with the policy after any school branding changes or updates to the policy. So that's section B is requiring AOE to make the model policy and including what needs to be in the model policy. And then subsection C on the top of page 3, line 1, is requiring school boards to adopt a policy. So each school board shall develop, adopt, and ensure implementation of and make available in the manner described under subdivision 563(1) of this title, a non-discriminatory school branding policy that shall be at least as comprehensive as the model policy developed by the Secretary. Any school board that fails to adopt such policy shall be presumed to have adopted the most current model policy published by the Secretary. Do
you mind if could you just tell us what the term model policy, what would that look like really? I mean, what would they actually be coming back with?
AOE,
and I'm sorry for my confusion, AOE, because it sounds like we've put in some guidelines, we've put in some certain things. So what is that model? What might it look like?
So the model, so what you are doing is directing AOE to make the ultimate policy on school branding in the state for the schools that you've identified here, public schools and approved independent schools. And it has to include these elements.
Okay.
How detailed it gets as far as process for review, whether they provide any context or more specifics is really up to AOE.
They could copy and paste and say, this is what you need. And they could give a few examples, and that could be the model policy.
It could be. I think that's a question better posed to AOE. And between now and tomorrow, what I can do is I can look at the hazing, harassment, and bullying statutes and the policy that AOE adopted to perhaps better answer that question for you.
Terrific.
But ultimately, I do think it's AOE might be able to provide you a better answer, but I'm happy to do that.
Thank you.
But yes, so they have to work out all the details, all the nitty gritty of the whole policy. And then each school board has to either adopt that model policy, so cut and paste AOE's model policy, or they can be more stringent.
Great.
And then there's a little bit of session law to end. So we started with session law, we're ending with session law, and that's just for implementation. So the agency shall adopt the model policy required in section 1 of this act no later than July 1. That was Ms. Simmons' one request, was to push that to August 1. I have not made that change yet.
Does anyone object to August 1? Okay, no objections.
And then school boards as defined in section 1 of this act, because remember, not the approved independent schools don't have a school board, so we have to refer to that definition. Shall adopt and implement school branding policies as required by section 1, and that should be section 2. That's just a drafting error of this act no later than January 1, 2023. And I don't think that date was in the AOE's proposal. I took that date from committee conversation yesterday, but that could certainly be changed. And then the last section is just requiring that school boards are reviewing their branding in place at the time the policy is adopted to ensure compliance with the policy. So it really leaves open the timing on coming into compliance as a local issue.
Say something else, if you don't mind, about that. So what exactly are we leaving to folks?
So all this does is require the adoption, implementation, and following of a policy. But there's nothing in here directing a timeline for coming into compliance with the policy. So if you want to change, the policy goes into effect, let's say in your school district on January 1, 2023. On February 1st, you suddenly want to become the, turtles. You'd have to come in, you would have that policy would control what your new school branding is. But if on January 1, 2023, your school branding was not in compliance with the policy adopted by your school board, the school board is directed to do a review, but there's no direction on how quickly that needs to happen, timelines, and then what to do if there is a disagreement on changing it.
Center Alliance.
I think we're back to one of the original questions we had about, are we asking local schools to review their branding on a regular basis? So, I mean, we have town plans that get reviewed every X number of years, and we have a lot of other things that go on a regular basis. Maybe we could simply suggest or state that town schools will review their branding every X number of years. And I don't know how that works. I don't think we're putting oversight into that. It would simply happen. And then if somebody wanted to have a complaint, that would be part of the complaint, but otherwise we're going to have this big enforcement stuff going on. It's like, which we were trying to avoid in the first place, just to allow people to review and make suggestions. So, yeah. So if they want to review that they're turtles and every 5 years, make sure that's what they want, we should ask them to do that. I don't know.
Okay, something to think about. Senator Perschlick.
Thank you, Chair. Beth, what did we do on that same question with the hazing, and what if a school didn't adopt that policy? What do they do?
So the hazing policy and this act or this bill requires the adoption of the policy, or the school board is determined to, let me find the exact wording so I don't butcher it here. Page 3, line 5 through 7, any school board that fails to adopt policy shall be presumed to have adopted the most current model policy published by the secretary. So it's the same as the hazing, harassment, and bullying, but that's just the adoption of the policy.
Right.
I did put in here a requirement that there's a review of the school branding to ensure compliance with the policy after any branding changes or updates to the policy, allowing for changes to that model policy as we evolve. And there is the requirement, or there is the opportunity for someone to file a complaint.
Right.
So I just wanted to flag that there was a lot of discussion in previous drafts of the mechanism of forcing school districts or schools that would be suddenly out of compliance with this new law into compliance. And I think the only way to force it in this draft is for someone to file a complaint that would go, but it certainly leaves open the possibility that there is voluntary compliance at the local level.
Senator Perschlick.
I'm still not clear on what happens if this is the same language from the hazing policy. What happens in that instance if they still have a hazing policy that's not in conformance with the state policy?
So I would have to go back and look specifically, but I think it's
Same problem,
the-
I guess is my question.
well, so the language is adopt such a policy. So there's a contemplation that it's a policy like the model policy or better than the model policy. I
Right.
shouldn't say better, depending on your opinion, more stringent than the model policy. But with hazing and harassment and bullying, you're stopping behavior in its tracks as it occurs. Here, it's kind of a look backwards at conduct that has already occurred and needs to come into compliance. Once that policy goes into effect and there is behavior that fits the definition of hazing, harassment, or bullying, you're either under the model policy because you didn't adopt a policy or the policy you adopted wasn't good enough, and you know what to do with it. Here, once the policy is adopted, I'm sorry.
So just to stop you, sorry, in that example, so what if they adopted the hazing policy, but then hazing occurs and they don't follow the policy, which I think that would be that would be the same with the mascot. Like if we adopted the new mascot policy that doesn't allow, aquatic hard shell animals to be mascots, but we're going to be the turtles anyway. Well, then
Right.
what happens in both those cases, whether the hazing or the turtles?
I don't know the answer to that question. I will say that the small amount of, I think I put together some reference material for someone on the hazing, harassment, and bullying policies in the state. So I have recently gleaned them. The policy is incredibly detailed and provides a lot of due process on both sides of the aisle. And so I don't know if there's any mechanisms built in for redress if someone believes that a school is not following the policy. But it is a very, very detailed policy with a lot of due process built into it. I don't know what AOE is going to do with this policy and whether they're going to build into their policy any.
But in general, any policy that AOE has, the schools need to follow. And if they don't follow, the only way you would know is somebody complains or if AOE found out. And I assume they have authority to do something to schools.
This bill as drafted doesn't really give AOE any authority to do anything other than adopt the model policy. You could certainly build and I think review, adopt the model policy, which includes a complaint mechanism, which is first decided at the local level and then may be appealed to the Secretary of Education. You could add language somewhere requiring that the model policy, whether it's in session law, so it's not necessarily a part of the model policy, or whether it is a part of the model policy in statute, that there be some sort of mechanism for forced compliance or how to address that non-compliance, but that's not contemplated here.
What
There's
if we
no
were-
enforcement. I mean, that's what I was saying earlier. I'm sorry, Senator Perch, look, I interrupted you, but there's no enforcement here. So even if there's a complaint and they're not following the policy, that's it.
Right.
So then it becomes a local discussion, which can escalate and be similar to what we've seen before. So unless there's some entity that maybe we put the Judicial Bureau in charge and give them a fine every day, but there's nothing there really.
Senator Perslow?
I just wonder about all the other policies that we have. And if I assume that the AOE has authority to enforce other policies that we have about the lead in the drinking water, or what's happening at the nurse's office or the curriculum, or they have to do standardized tests. I mean, some of that's federal law and it's tied to money, but I assume there's a bunch of other stuff that,
Well, anti-discrimination policy. I don't know if
yeah,
that's,
well, that probably is a complaint.
Yeah.
But if there's anything in that they don't do, how do we have enforcement mechanisms for every single policy written? Or is there some kind of overarching, if AOE has a rule, or maybe it has to be a rule and not a policy for it to be just automatically enforceable, is my question.
not yet.
You're still muted.
We can though read your lips.
Can you hear me?
Yes.
My my fabulous piece of technology died.
No problem. So as you're working on that, so we're looking for what is that, what is the enforcement piece? I mean, is there a review in 2 years that, where the agent, I'm just thinking aloud, where the agency reviews to sort of see where every district is in 2 years? This committee, it's sent to the legislature, a report in 2 years that would, after this policy is put in place, all the mascots, there's a mascot review group that reports to the legislature and the Agency of Education to see, successes and failures of this policy, and then gives people an opportunity to say, hey, in general, things look pretty good. Or, hey, it looks like there's still some concerns. I don't know. Senator Perslick, were you going to add to what you said before we go to Senator Lyons? No, Senator Lyons.
So in the iteration from the state board, there were carrots, the incentive to have new uniforms. And we don't have sticks with this one. So the question about other policies might help. Are there any penalties for not doing something that takes money away from a school district? I mean, can we say you're not getting any money for branding? I don't know. I just think this is something that schools and people will want to do. I don't think they're going to want not to do it, but sometimes the disincentive is the thing that works the best. So maybe the question about, are there other, I think Senator Perswick's question about, are there other policies that have, enforcement pieces or penalty pieces that would ensure that the review and the change went on? I don't know.
I mean, we could put it back in there, the piece about,
the incentive
I personally
piece.
don't like the penalties, with
I don't
kids.
either. That's why I say I
anything
like the
that.
incentive piece so much better.
Yeah. We could always put the language back in around, incentivizing. Senator Chittenden.
My experience with policies like this, when you have administrators charged with the task to oversee an institution like a school district or a municipality, they're going to abide by the policy. And if they were to break from it, it would be under the direction of their board. And I think where that might come into play, and maybe this is, I need to understand this better, but if a school is in non-conformance with a statewide policy, wouldn't that dismiss them or make them eligible for any like statewide grants, like almost grant forms? Don't they have pretty standard language? And that there's so much money that comes from the state for different funds that I would assume a school district in blatant objection or non-conformance with a policy would just then not be considered for some of those monies. But is that not the current case? I don't know.
St. James?
I don't know the answer to that. I think these are all great questions that I could spend a lot of time trying to research, but you might get a very quick answer by inviting AOE to answer some of them, and a more accurate answer, because I can give you what I think my interpretation would be, and AOE will give you what they will actually do.
Daphne, would you please have Ms. Simmons come in tomorrow?
Yes, I'll reach out.
And I guess the other thing, just along Senator Chittenden's good comments, it is kind of interesting that we're all sort of focused on the what if they don't. I mean, myself included. It's like, what if they don't? These are good people working to do the right thing. This is a new policy that we're saying. It's sort of like some new anti-discrimination policy. I mean, in terms of, okay, now we have a policy that you're not going to discriminate against LGBTQ people, or, we're trusting people to do the right thing. We're putting in some new language and statute, new guidelines. Doesn't mean we have to come down with a hammer. I think Senator Chittenden raises a good point. Senator Hooker.
And I would hope that that would be the case, certainly. And I seem to remember the secretary saying something about grants or not being eligible for grants if boards weren't in compliance. My question is, do we have anything in here, like this whole thing now is predicated on existing mascots for the ones that are in existence now, and a
Current
review
issue.
of-
Yeah.
and a review of those mascots. Is there anything in this legislation that says you have to review those? Maybe it's a question. Okay, so it's telling them you have to do it. You have to do it, not just adopt the policy, but you have to do it within a certain period of time. And then,
That is adopting it. I mean, you're saying it's like discrimination, or, there's a new policy. It's over. You can no longer discriminate. I mean, this is saying this is a new policy. Time to rethink your mascots, basically.
Section on page 3, it's the very last substantive piece, subsection C in section 3 of the session law. It says school board shall review the district school branding in place at the time the policy is adopted to ensure compliance with the policy. That's it. There's no, you could add a date by a certain date, no later than.
I don't know. I keep going back to sort of, I think what Senator Chin was saying, we pass laws all the time. We trust people to take this is a complete policy change, So now we are in this situation because there isn't direction. We're giving direction. No more of this kind of mascot. We do this in law all the time. We make these kinds of policy shifts. And I don't know if we're always sitting there. So I don't know if we have to have a hammer, really. I mean, we can review this in 2 years. If it's a mess, then we know we've failed. But I have a feeling people are going to take this, and between the school officials and the elected officials, people will make the necessary changes.
Senator Campion, can I ask a question?
Absolutely.
I'm sorry, I don't have the hand raising.
No
So go back to the Rutland situation. I heard over the last week from 2 different school board members that once they reinstated recently the Raider name from the Raven name that was short-lived, that motion included to remove the arrowhead and any sort of Native American symbolism or symbols or icons. So who, for example, would be the determining factor if the word Raider as a nickname is inappropriate at this time or not, especially after we had a long discussion if a Raider means anything or does represent a Native American culture or doesn't. I'm just trying to figure out who would be the deciding factor with the current language in the bill.
That would be the school board would be the first step. And then if there was let's see. So if there's a complaint filed, if an individual says, I think that this mascot or school branding violates the policy, then the school board would be the first layer of determination. And then if the individual who filed the complaint is unsatisfied with the decision of the board, that decision can be appealed to the Secretary of Education. It's a little less clear, although it's a little less clear on what would happen if it was the school board doing its own review once the policy is adopted, whether the school board's decision could be appealed by someone else to the Secretary of Education. That's there is no provision for what happens if the school board is doing its own review to ensure compliance. But for a complaint by an individual, it would be the school board and then the Secretary of Education.
Thank you.
Does that make sense, Senator Terenzini? So once this is, again, it would be a completely, and I'm also saying it just for my own benefit here and understanding, this is a new policy. We're saying, okay, no more of certain kinds of mascots, goes to the school boards. Those school boards make the necessary changes in conjunction, in tandem with administrators, students, et cetera. And then if somebody disagrees with that final decision, it can be appealed, or if the school board ignores what we're putting forward, if they feel like, hey, we've got, ours fit within this new model policy, which many, I suspect, will, most, 85%, I suspect, will. And then somebody says, well, no, I'm not in agreement, then that is appealed to the Secretary of Education. And that's where he or she, looking now to Ms. St. James, would make the determination.
Yes, the appeal would go directly to the Agency of Education.
Okay.
So I appreciate it, Senator Campion. I am following along. I think it's, and I only go back to the Rutland issue, obviously, because this is the district I represent, along with Senator Hooker and Collimore. But if Rutland was the Rutland Chiefs or Indians or the Redskins, and thankfully the Washington has a new name in the football in the NFL. But if it was really clear cut, then we would know the steps. I just can see, as I've said all along, I want to maintain the Raider name and get rid of the logo. But I can just see how Raider doesn't really mean anything. So I could see how this could continue to be a mess if someone wanted to challenge the Raider name, which we can assume would happen on day one of this becoming law.
Sure. Well, I think you're always going to have any kind of appeals out there for a lot of different kind of policies, whether it's, just thinking fish, I serve on natural resources, fish and wildlife stuff, renewable energy as it relates to siting. I mean, all sorts of appeals and concerns could be raised. Absolutely. Okay. Senator Hooker.
With regard to the Raider name and the logo and what does the word mean? I mean, there are a lot of words that have more than one meaning, certainly, but the point I think about the mascot is to look at the history of the logo, the history of the things that represent the school, that represent that particular word. And I guess that would be where I'd come down. The school board would need to take a look at what the history was.
Right. And these are, these would be school board decisions. And we know school boards are changing. We know all sorts of things are happening. It's a tough thing to predict. I just don't know how what we're doing as a legislature would be saying, here's the model policy. These are the groups that we do not want mascots to represent in a negative way. And then giving that direction, and we would see where different boards, just like we've made other laws, hoping to change policy and see where people fall, what they decide. Okay. So we're going to hear from Emily Simmons tomorrow. And in the meantime, let's keep asking questions. I get it. It's a tricky one. I know we're also being inundated with emails, and I do appreciate the support, and to do something, to give people, greater policy, direction. And I think a lot of young people in particular are interested in this, which I say inundated in a positive way. Great. Okay. Ms. St. James, thanks very much.
Are you gonna, I assume we'll take this up again tomorrow when,
We will with
Okay.
Ms. Simmons and better
Great.
understand, what I think you've helped us to really recognize is what kinds of things would the agency do if given this situation where if the Raiders, it's appeal, what kind of enforcement and what kind of appeals, how would they handle that sort of thing? Great, thank you. Mr. Demarais, thanks for joining us on 219.
Yes, nice to see you. Should we start on 219?
I'd like to start, if you wouldn't mind, with the memo from Ms. Zaglowski et al. And you had, or actually, we don't have to start with this, but at some point before the end of the day, I'd like to just review your thinking on it and your response so we can, so senators have an opportunity to think about this a little bit more this evening.
Sure. I can start with that if you like.
I would, yeah, if you wouldn't mind,
Yeah,
that would be
yeah.
great.
So,
Really in the context of the discrimination section of the memo. Because I do think the committee has decided not to wait a year. The committee's decided, guidelines are essential. Anti-discrimination policy is essential. And so with that, the floor is yours.
Okay, so for the record, Jim Dameroy, alleged counsel. The testimony that Chair Campion is referring to came in today. I believe it was on behalf of a number of the V's from my school board association, I think the superintendents and maybe the NEA. And it made 3 points around the discrimination language. The first point was questioning whether it required independent schools to comply with all anti-discrimination laws that apply to public schools. And the language, I believe, does that. It says all anti-discrimination laws, state and federal. I did make a small tweak to the language, though, to reemphasize that, which when we walk through, I'll show you that language. But I do believe it covers, it prohibits independent schools who are eligible to receive public tuition, prohibits them from discriminating against, prevents them from, requires them to comply with the same anti-discrimination laws that apply to public schools, full stop. That's the intent. I think that's what it says. Second, she raises a point about the students on IEP and whether the bill requires compliance not just with admission of students on IEP, but also all the services required for that student. And that is already in law. That was part of Act 173, and there's a statute in place now that addresses that point. So I hope that responds to her concern there. And the third point she raised is one that you've discussed before, which is what about enforcement? Who's got the right to enforce this? And do individuals like students and staff have a private right of action to bring a claim under this bill? And the bill is oriented toward state board approval. So the bill's orientation is that these conditions are necessary in order to be eligible for public tuition. So the consequence of not complying is the board can revoke your eligibility for public tuition. It's not designed today to create new rights of private action. I think in order to achieve that, you have to maybe amend the other laws, like the Vermont Public Accommodations Law and a number of other laws to have them directly apply to the approved independent schools. And I'm not even sure that's possible because some of those laws are written in a way to, for example, the Vermont Public Accommodations Law, as we've talked about, applies to schools, but only if they serve the general public. So I don't know, you could just go into the law and say, regardless of that condition, it applies to every private school. You're doing it as a condition to get eligibility to get public funds. That's a different story. But going into
I
those laws,
remember this discussion a little bit where we were all thinking, what is the hammer, if you will? You know, what is the consequence? And the consequences are you don't get funded.
you don't get funded.
Yeah.
And it's possible that the language would create a private right of action. I don't know, because I'm not a litigator. I don't know how to assess that. But the design of it it's not been designed for that purpose. So those are the three main comments I think that testimony was raising in the context of anti-discrimination.
Any questions for Mr. Desmarais? Okay, that's very helpful. Okay, should we take a look at draft 752.3?
We were actually in draft 5.5, but it's actually version 12. So there's been 12 versions of this along the way. So the changes are very few. On page 3, you've got new language on lines 18 and 19. And this is the point I just discussed. So just reading from line 12, it says, one of the conditions is that the school has adopted and implemented policies and procedures to comply with all federal and state anti-discrimination laws applicable to Vermont public schools and makes reasonable efforts to enforce. That was there before, and it says all. And then the next sentence calls out a few specific acts. The Vermont Public Accommodations Act and Vermont Fair Employment Practices Act. And they're called out because there's been a lot of question about their applicability in this context. So I'm calling these out here to say these do apply. But then I've added language on lines 18 and 19 to say, and all other federal and state anti-discrimination laws that apply to public schools. So I'm just bringing out that language again, so it's not forgotten about in this list. So that's the first change. Second change is on page 18 and goes to the question of taking public tuition and using it out of state. And you will recall that there are a few exceptions. So you can only use public tuition in states that in Vermont or states that border Vermont or in Quebec. But you have exceptions that allow use in other states or countries. If the student's on IEP, if the student's on a 504 plan, and what's new here is lines 18 through 20, where the student is determined to be disabled by the evaluation planning team or local education representative under State Board of Education rules. So there's a process currently in rules that has schools evaluate students for a disability. It's part of the process to get an IEP. The first step is to determine whether the student has a disability. So this is a process that's in place today, sorry, and adds a verification element here. So it's not a parent saying my kid's disabled, it's actually a process that has that determination. What's missing from this language is the D section, which was a general exception that you could apply to your school board to use tuition in other countries or other states. But that raised the whole problem of this local school districts having to know what those other schools offer in Vermont, in bordering states, in Quebec, and that's impossible. So that's been taken out of this draft, both because it was kind of unworkable, and you have 3 exceptions here already for these categories. And I would imagine that for other students who aren't disabled, who aren't on 504 plans, who aren't on IEPs, that schools in Vermont, bordering states, Quebec can probably offer what they need. So that's why it's been taken out.
Okay.
And the last change is on page 22. It's a conforming change to the change we did on page 3. So this is when you get into the contract itself between the state board and the school. Same language as on page 3, just making sure that it covers all discrimination, anti-discrimination laws. And that's it.
Okay. Any questions for Mr. Demarais, who continues to do incredible work on this?
So can I clarify one thing? I have that testimony before me. So it came from Sue Glowski, Jeff Fannin, Jeff Francis, and Jane Nichols.
Yes, thank you. And everyone has received that memo, and we appreciate your feedback. So any questions on Ledge Council's response to the memo or the changes? Okay. Great. So we will have Sue Siglowski in tomorrow. I think this is teed up to vote either tomorrow or Friday, depending on last minute bits of testimony. Corner office knows. And so, yeah, that, and then Senator Chittenden, please.
I should know this, but the crossover deadline is this Friday or a week after we come back after the break?
The week after. It's the Friday after we come back. So I like getting my papers done early, just in case, because generally there might be a little, give myself a little, I don't like asking for extensions. Senator Perschlick.
Typical overachiever.
Yeah, no, I'm really not actually at all. It's just that I was never, I always needed somebody to read my papers. In this case, it's really Mr. Demarais who's knocking it out of the park. If I were the lawyer, I'd already be planning an extension. Thanks, Jim. Anything else for Mr. Demarais, who will likely be traveling the United States this summer, doing PowerPoints on this kind of bill?
I'll be retired. Thank you very much.
Well, retired from one job. All right. So thanks, everybody. Thanks, Jim. This has been great. And Daphne, if you want to take us offline, I think we're